This is case number 21-140-786. This is Michigan Comprehensive Shrine versus City of Detroit. The matter is set for review on today's date. Your appearance for Michigan Comprehensive, please.
Philip Jaffe, P25997 for the plaintiff.
Thank you, Mr. Jaffe. Good morning to you. For the City of Detroit, you may at this time, Council.
Good morning, Your Honor. Alfred Ashew, P82536 on behalf of defendant City of Detroit.
Thank you, Mr. Ashew, and good morning to you as well, sir. Somebody update me on this. I knew you were having some problems getting it resolved last time here. Update me on what they are at this point.
So I think the last time we were here, we were awaiting defendant taking the deposition of plaintiff, which thereafter occurred. And that's where we're at right now. But I believe maybe the defendant has something to add to that.
All right, so you haven't gotten that deposition for the provider taken. I think that's what was outstanding. Update me from your perspective at this time, Mr. Ashew.
Yes, Your Honor. We were able to take that deposition this month following a motion to compel. And based upon the testimony received in that deposition, we would like to obtain leave to file a motion for summary disposition.
Sure. How much time do you think you need to do that? And I think you were anticipating that, Mr. Jaffe. Is that correct, sir?
I was anticipating it only because counsel and I have exchanged emails today. So,
But I don't know.
Your Honor, if I may,
but that's all I know about it. I'm not agreeing with it. But I know about it.
Of course. I didn't mean to insinuate any agreement.
Your Honor, if I may, I'm not sure if it's just me, but your volume is extremely low. It's difficult to hear you. It may be just me. I'm not sure if Mr. Jaffe can hear you.
It's low.
Okay.
Very faint.
Okay, are we better now?
Getting
A
better.
little bit.
Yeah. Right. We had this problem
That ain't gonna
yesterday.
help it.
Okay.
Turn it up.
Yeah, I had court, man. I wonder if I'm in the right courtroom. They said I was in the wrong courtroom. I got Zoom far as my court. You ain't got the I probably in room 337. I'm trying to figure out how you work that shit.
Is that Mr. Wilson?
Your last name Wilson? Yeah, this is yeah, you might be in the room with your
Yes, sir. You got a bag out of here. You're going to be in 33. You said 337 or 336?
excuse me?
Did you say 337 or 336, sir? Are you here for judge?
337.
Okay, so you got a bag out of here, and then you're gonna enter in the meeting ID section where it says enter meeting ID 360-337-0000, sir.
Hold on, somebody helping me. Hold on.
Okay.
Say that again.
360
3601.
337 0000.
Hey, can you hear me?
Yes, sir.
Where am I typing this at? Am I just saving it in my notes or just typing
Nope.
it?
So you got to leave this meeting that you're in right now. Then it's going to have you enter a meeting ID number at the beginning of the screen. Once you basically however you process to put the information in on your Zoom.
All right. Hold on 1 second, because I'm about to put it in on my phone. I'm about to just put the numbers in on my phone real quick.
Mr. Wilson, you're gonna have to hang up here and go to the next courtroom. Do everything that you did to get it for like 360 something. And then you gotta put the middle three numbers. The middle three numbers are the only thing that you need to do different. And those middle three numbers are.
Okay, what's the number?
337.
337.
337. Okay?
That's 337.
Right, then that's the middle number. Do everything else that you did to come into this zone. The same thing you did.
Okay, so far I got 337, sir.
That's all you need. That's all you need is those middle numbers. You already have the first three numbers, 360, then you put that middle number in and then 0000. Good day to you, sir. All right, that's about the best I can get. I'm gonna try to keep my voice up, and if that is not loud enough, just let me know so I make sure that everybody is able to hear what I'm communicating. That okay, Mr. Ashu?
That's fine, Your Honor.
All right, we're trying to keep it going. All right, so looks like I need to set this on for a motion hearing in January. And so we're gonna give you a specific date now, so you can come back and report.
Okay.
January. Well, sometime in the middle of January, you think, Judge?
Yeah, the third week of January.
The 19th.
119, 22 is gonna be the hearing date. You'll get a notice in that regard. So I know the busyness of this season, so, you know, you file your motion as long as it's, as long as it gives the defendant at least 14 days to respond to the motion, then I'll hear it on the 19th. So at whatever point you file it, as long as Mr. Jaffe has at least 14 days to respond prior to the hearing date, that will be sufficient to resolve and make sure it's heard on that day. So 1/19/22, that's going to be at 9:45 a.m.
Thank you, Your Honor.
Thank you.
Thank you. Good day to the two of you. The court now calls case number 21-162-348. This is Michigan First Rehab versus Nationwide Mutual Fire Insurance. The matter is before the court, set on for a status conference on today's date. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Sandra Toma appearing on behalf of Plaintiff Michigan First Rehab, P number 84575.
Ms. Toma, good morning to you and thank you. And for the defendant regarding this matter, your appearance at this time, please.
Morning, Your Honor. Kevin Capone appearing on behalf of the defendant Nationwide, P number 82518.
All right, thank you, Mr. Capone, and good morning to you as well, sir. All right, so it looks like you're just getting on the way here, and I have it set for a status conference. Have you done any discovery, any initial disclosures or anything at this point?
Your Honor, we did send out discovery to plaintiff. We received some responses, and I was talking to plaintiff counsel earlier this morning, and she's advised me that the other responses are ready to be sent out. They're just waiting for some records from their from the provider, so those should be coming or should be provided shortly, I believe. And then the only other thing I would like to have in discovery is just the deposition of Mr. Dawson, the claimant. I do have another case with multiple providers in Wayne County for Mr. Dawson, so I could schedule it in that case, or I could schedule it here, or do both. Whatever this court is willing to accommodate, I'm able to do.
Thank you, sir. All right, good enough. Ms. Toma, anything you wish to add to that?
No, that's it, Your Honor. I have no problem with them taking the deposition of the underlying patient.
So what I'm going to do is I'm going to set it on a 60-day discovery period. It'll actually be a little bit beyond the 60 days, but I'm going to set it up for its next hearing regarding this matter. So that's going to put us
In February,
yeah, that's going to put us in February
February 14th.
2/14/22, and I'll allow open discovery through that date, through the 14th of February. It seems that the two of you are moving along well in regard to making this happen. And if you need additional time, I'll visit that issue on the 14th. Also, I will indicate that on that date, the 14th, I will hear any motion that you filed, dispositive or otherwise, before the court, so long as you provide at least 7 days opportunity for the opposing party to respond. So whether it's a dispositive motion or a non-dispositive, in either case, if you file a motion and set it for hearing on the 14th of February, as long as you've allowed the other side to have at least 7 days to respond to your motion, I will hear the motion on the 14th of February. So that keeps things moving along. We'll address any other issues at that time. Hopefully the case will be in a posture where either there is something, someone moving for something dispositive, or the parties are moving towards seeing what the values are in the case, of whether or not it can be resolved. So we'll take a look at it at that time. So it's going to be February the 14th, and that's going to be at 9:30 a.m. And you will get a written scheduling order from the court, and you'll receive a notice of that hearing date as well, but you want to know it 2/14 at 9:30 a.m. Good day.
Thank you, Your Honor.
Thank you, Your Honor.
All right, this is case number 21-160-571. This is Aligned Rehabilitation LLC versus City of Detroit. The matter is before the court, set on for a status conference. Your appearance now for Aligned Rehab, please.
Good morning, Your Honor. Good morning to your staff. Fahad Mackey on behalf of Plaintiff Aligned Rehabilitation.
All right.
Morning, Your Honor. Philip Hiltner, P77913 on behalf of the defendant.
All right, thank you, Mr. Hilmer. Good morning to you, Mr. Mackey. Good morning to you. Mr. Mackey, did you put your P number on? If not, go ahead and do so if you will, sir.
82776.
All right, thank you, counsel.
Thank you.
Good morning to both of you. Looks like this case is kind of just getting started. It looks like it's a provider case, is that correct?
That is correct, Your Honor.
All right. So update me, any initial disclosures, any special information that's needed? Talk to me at this time.
Our initial disclosures, witness lists were filed with the court in September. I received the defendant's answer. I don't know if Mr. Hiltner has submitted his initial disclosures and witnesses. I don't believe I received them. And then I also don't have a claim file. So in terms of the preliminary matters, that would be plaintiff's posture at this time.
Thank you.
Yes, Your Honor. I don't believe discovery has been. I did receive initial disclosures from plaintiff, which I appreciate, but I don't believe discovery has been ordered or opened. I would request that we be allowed a discovery period.
Yeah.
But all right, we haven't provided anything because I don't believe discovery has been allowed yet in this case.
Well, the absence of an order of discovery doesn't prevent you from providing information, but it doesn't, obviously you're not under any kind of order to do so. Certainly this hearing, at this hearing, I will set up an order of discovery, and I will grant, and it the way that I try to approach this is to see just about how much might be needed to talk about the horizons, how much time it would take to get this done. So I'll go ahead and set it on that date that you might have heard earlier. That's going to be February 14. That gives you just beyond the 30 days or 60 days, I'm sorry, discovery, a little bit longer than that period. And I will allow for open exchange of discovery during that period of time and up till that particular day. I'm also going to do, as you heard me indicate to you, that you can file motions dispositive and otherwise, and set them for hearing on the 14th. And I will hear the motion at that time, so long as you, so long as you provide at least 7 days notice to the other side. In other words, they've got to have 7 days, opportunity to respond. And, so long as that is the case, I will hear a motion that you filed, and set for hearing on that date. And that's going to be at 9:45 on the 14th of February. All right.
9:45. Okay, thank you, Your Honor.
Thank you, Your Honor.
Thank you. Day two, gentlemen.
Good day to you, Your Honor.
Mm-mm. Yeah, yeah. Coming back, Mr. Hillman, they're coming back for the last case you just did, come back for a pre-trial.
Um, yeah, for, both of those cases.
morning, Your Honor.
I was like, oh, he called like around the end of the day, and I was like, oh my goodness.
Yeah.
Okay, all right, cool.
We had a chance, thanks.
Good.
I didn't even know you reached out.
Yeah, yeah.
But I'll make that call and say for you. Okay, so I know that it's, but I just wanted to, that I will still have, I said, your attorney, of our material, trying to make, you see it, make sure that I know it's. All right, thank you all. I had a motion and then I have a case for Your Honor. But I guess you can correct me if I'm wrong. I think her motion filed. There are timing issues there. Injunction motion, Your Honor.
This is case number 21, 162798. This is Metro Med Pain Management versus City of Detroit. Matter is before the court, set on for a status conference, scheduling order, scheduling conference on Tuesday. Your appearance for the plaintiff in this matter.
Good morning, Your Honor. Joe DeCrib on behalf of the plaintiff.
The OP number, if you will, for the record, sir.
I'm sorry, Your Honor. P84445.
I know I've seen you here somewhere before on at least another case. All right, and Madam Counsel, I've seen you before. Your appearance on this matter.
Yes, Gina Smith Gallant, P41387, on behalf of the City of Detroit.
All right, thank you, Ms. Gallant. Good morning to you. Good to see both of you. This case looks like it's just starting out. I heard my volume maybe a little bit low, so if you don't hear me, just let me know. And,
Barely.
I don't know what's going on today, but we're trying to keep up, right? So, so how far have you gotten with this? Any initial disclosures? How much time do you think you need for discovery? What's going on? Somebody update.
Your Honor, we have not gotten the initial disclosures. Did you send them, Mr. DeCruz? I have not received them. And I'm thinking sometimes that our firm just got this case recently and filed appearances, but I'm not sure if sometimes things are sent to the City of Detroit, but we definitely need initial disclosures. It's not a large amount involved here, but we just need details, data services, medical reports substantiating. So we do need some discovery.
retry cases. Same.
All right, very well. I will go ahead then, Mr. Core, anything you wanted to bring to the board's attention, sir?
Let's see what happens. Things get prolonged.
Your Honor, I'm sorry, Gina, we sent out initial disclosures 2 weeks ago. So if you
Oh,
didn't get
did
them,
you?
yes, we'll have them resent to your office.
Could you send them to me? I don't know if they, well, yeah, just send them, or you can email me.
I will email them to you.
That might work out better. And then I'll send you ours.
I will have them emailed directly to you.
Okay, I appreciate it.
All right, sounds good. What I'm gonna do is, I'm gonna go ahead and set it up on, like 60 days out. The date I'm working with now is 2/14/22. That would be at 10 o'clock a.m. I'll set that for a pretrial conference. And so discovery will be open through that time, and also allow that to be a date for motion hearings, so long as you file your motion early enough for the opposing party to have at least 7 days to respond. Then the court will hear it on that date. So whether it's a dispositive motion or not, if you file your motion and set it for hearing on the 14th of February, as long as you've allowed the other side to have at least 7 days to motion.
Okay, that sounds good.
All right, so I wish you well. You'll receive an order from me with that information shortly.
Your Honor, on February 14th, what time will we be coming back?
10.
10 o'clock a.m.
Your Honor, I just want you to note that that is Valentine's Day, and we will be happy to see you on Valentine's Day, Your Honor.
Absolutely, man. It's all my clerk. It's all my clerk's fault.
All right.
No problem, Your Honor. You have a good day, Gina. I'd be happy to see you too on Valentine's Day.
All right, bring the candy, Joe. Okay.
I will. You know I will. The
Thank
stomach
you.
doesn't lie. Take care.
Bye-bye.
Good day to you.
Mhm. This was at 9:30. Yeah, this one. It's right. I mean, the date is right. It's just the time. 9:30.
You sent out another note. Want me to change that?
No, you don't have to, man. They'll be here just a little early, but it'll still be on there.
All right, just one moment, sir. We'll be right with you.
You might want to get comfortable. We might be here for an hour or so. Well, I'm not saying that.
Hey, how you doing, sir?
Hello, Your Honor.
This is the court officer, sir. Can you mute your microphone, sir?
Yes, Your Honor, William Saloom for Discover Bank. I don't think it's up.
I'll be right with you. Just one moment, sir.
Thank you. Thank you, Your Honor.
I still hear this. Are you by yourself? I'm by myself, but there's a hallway way down.
All right, this is case number 21-148316. This is Discover Bank versus Shuri J. Fry. The matter is before the court. Set on it for a motion to set aside default in this matter. Your appearance for the plaintiff at this time.
Yes, good morning, Your Honor. For the record, William Saloom of counsel to Buckles and Buckles, P41487, appearing on behalf of plaintiff Discover Bank.
All right, thank you, counsel, and good morning to you. Do I have Shirley Fry on this Zoom? If you were here, say something at this time, please.
First name is Surrey, Surry. Last name is Fry, Fry.
Thank you, Mr. Fry, and good morning to you, sir.
Good morning.
So, counsel, I see a motion for summary disposition in this matter. I also, let me just look at one thing here. And I saw something indicating a motion to set aside a default in this matter.
Your Honor, I think it was a dismissal, a motion to set aside dismissal, I believe. I could be wrong, but I think what happened is I appeared for a court date a while ago on this matter, and the court said it was not up. And then there was a return date. And I don't know if between those dates it got dismissed, possibly.
No. It was, may I speak?
No,
May I speak?
not yet. No.
Okay.
Not yet.
Okay.
I do have an order on the 26th of August of 2021 indicates that I dismissed a case where the plaintiff did not appear. Subsequent to that time, I received a motion. I received a motion to set aside dismissal, and in the petition to set the dismissal aside, the plaintiff has indicated that they were not aware of that particular date. Is that what it is, counsel? I can't hear you, sir. I believe you're on mute. Is that what's being brought before the court at this time? You're on mute, counsel.
Your Honor, can you hear me?
Yeah, I hear you now.
Okay. No, I think the court is correct. I think it's our motion to set aside the dismissal, I believe. That's my understanding.
Thank you, sir. And Mr. Fry, you agree that that the case was dismissed, correct, sir?
Yes, the case is dismissed. Betsy, whoever received all the information, they didn't show up. It was vice versa. I really think they would have gave me a harpoon through my throat. So they didn't show up. As far as I'm concerned, it's dismissed.
Yeah, it is dismissed. The issue that they bring before the court is they're asking the court to reinstate the case. And in these kind of situations, the case is typically reinstated because the dismissal was without prejudice. So I will set the dismissal aside. That would be the same thing that would happen if you had a case against someone, Mr. Surley, and it was dismissed because you weren't here. I would reinstate the case unless there was just some extraordinary circumstances. The case would typically be reinstated. So that's what's going to happen here. The case will be reinstated. That means that we pick up where we left off when the case was initially dismissed. All right.
Thank you, Your
So,
Honor.
all right, no problem. So what's going on here? I do see a motion now for summary disposition in this matter. This looks like a claim that there was some type of account that the account had a balance on it, and that balance hasn't been paid. That's basically what the allegations are. It looks like the allegations are that balance is in excess of $15,000 or $14,000, correct, sir?
If you're saying Sherry, I didn't hear you, but I'm not sure. I've been paying Discover. And I don't know if.
Not yet, Mr. Fry, not yet, sir.
Okay.
Oh, Your Honor, are you asking? Yeah, the court is correct. The amount claimed on the credit card account is approximately $14,000.
All right, Mr. Fry, you disagree with what is it that you disagree with the amount, and what else do you disagree with?
Yeah,
about?
well, no, I don't. I disagree with. I agree with the fact that it's approximate. I think we need another count on that, but it's approximate. I do owe Discover Bank.
All right. So what are you asking? What are you asking the court to do in regard to this matter? How do you want to go about dealing with that? The fact that because it seems like you admit to me that there is something that's owed. So how do you want to proceed in that regard, sir?
Mr. Fry, correct?
Yes, sir, Mr. Fry.
I would like to set up a payment plan. I was going to start employment this week. I mentioned that I had to take time out for this, and they told me either they'll allow me to start mid-December or beginning of the year. So I would like to bring it back and decide on maybe a payment plan based on other hardships I have as far as financial is concerned because of the COVID-19 situation.
Yes, sir. Yes, sir. So why don't I do this, Counsel? Why don't I have the two of you talk in a breakout room?
Yes, Your Honor.
I'm sorry.
That sounds good.
See if you can do two things, or one of two things. One is see if there is any room to compromise on the amount that's owed. If there's any room to compromise on the overall amount. And then secondly, if some accommodation can be reached in terms of payments towards satisfying it, and how soon those payments would be initiated. So take a moment to both sides to negotiate, see if you can reduce it a little bit and get you a reasonable monthly payment. Counsel has some constraints because he works for a client, but you put on the table what you'd like to see happen. Maybe you can work something out. Mr. Fry, you understand?
I understand.
Okay. So I'm going to put you to in breakout room number 1, and I'll stand by. You can come back in once you have a chance to talk, and we'll see where we go from here. Okay?
Thank you, Your Honor.
You got this?
Yeah.
No.
No, oh, I don't know if it's stuck, might be stuck. No, that's mine. Mhm.
Okay, don't worry about it. It didn't come through.
No, it's because it was stuck, I think. Let me see, I think it's a jam.
Dollar Tree permanently raise prices.
It's never a dollar.
What?
He was just saying about the dollar store. Raise them on prices.
Oh, yeah, I heard about that.
Old stuff, $1 to $1.25.
I heard about that. Out of control.
It's like that. It's like at the low 5 store. They did that almost 2 years ago. You know, everything was there $5 or below.
Mhm.
And they call it 5.
Mhm.
But now, I'm going 5 below. Yeah, stuff. Welcome back, gentlemen. That was quicker than I anticipated. Let's see. Somebody update me. Tell me what kind of progress was made, if any.
Yes, Your Honor. So I had explained to the defendant that we could do a lump sum or that we could do monthly payments. And I explained what we could reduce it to. He wants to think about it. And I don't have a problem with us getting a return date early next year. Does the court want the motion to be held in abeyance, or I don't know how the court wants to deal with the motion, or maybe have the motion heard at the next court date, if that's acceptable?
Yeah, basically, what I do is just carry over it and set another hearing, and then the motion will be heard on that date. But and of course, if the parties have worked out, then the motion will be moved at that.
Yeah, I think that seems reasonable. I think he wants the date to be sometime in February, if that's convenient to the court docket. I'm fine with that.
All right, so I'll set it early February, and I'll set it for
17th.
I'll set it for a motion hearing and review date on February.
You already have a lot on. What about the 17th?
I don't want to go that far.
You want to do the? You don't want to go.
17th is good.
That's a little far from me. 8 or 9.
That was a lot. Third.
It's
Not the 7th.
Hold on a second.
February 7th.
February 7th.
That's fine. 7th, Your Honor.
Yeah, February 7th, 2022. And that will be the return date. You'll get a notice in the mail. It's going to be at 9:30 a.m.
Okay, sounds good.
2/7/22 at 9:30 a.m. It'll be a pretrial motion hearing and review hearing. Hopefully you got it resolved by that point. If not, we'll deal with the motion and we'll figure out where this case goes from there. All right.
Thank you very much, Your
Honor. Thank you, Councilman. Wish you well, Mr. Fryer. We'll see you on the 7th of February. Sir.
Have a great
good
day. Thank you, William.
Yep, thank you. Have a good weekend or good holiday season coming up.
Yep.
Like no dates. It's like we almost pushed to March because of the way these defaults coming in. I don't know if they just want to sue everybody or what. There's like no date.
Well, we start putting them. Maybe we might have to go to, one after.
But then, okay. So what about?